next step in a court case is a settlement conference. And this is where that new rule that popped up that gave rise to the whole poster. So at a settlement conference, there is a rule, Rule 20.2, that talks about experts and expert reports. Okay, and there are different types of experts, which is beyond this video. But here are the types of things that require expert reports. Okay, now a pension valuation is generally done if you have a provincial pension, it's generally done through the administrator. So you don't actually need to hire an expert. However, if you have a federal pension that needs to be valued under provincial legislation, you can say that 10 times fast, you do need to hire somebody to put a value. Let's just bring this back a little bit simpler. You know, on your financial statement, you have a line item that says bank account, and it says $300. So back in stage 2, you found a bank statement, you know, you saved to PDF, whatever, that says $300, and you've proven the line item, and you're done. But what about some items that don't have a piece of paper, that you need some form of opinion? And all of these things in these bullets, pension valuation, property appraisal, business appraisal, certain disposition costs, which are liabilities attached to certain assets. So just as a simple example, if you have an RRSP account, you are allowed to deduct the tax that would notionally be paid on it, because $1 in an RSP is not the same as $1 in your bank account because of the tax issue. Okay. And sometimes when income is complicated, there would need to be an income report, which requires different types of experts to give opinion evidence in the form of a report. Okay, the most simplest one to understand is actually the property appraisal. You go to a property appraiser in order to find out how much the house is worth.
Right.
That's right? Okay.
Yeah, that's easy to understand. Yeah.
Okay. The rule says that by the time you get to the settlement conference, you have to have these reports done. You shouldn't be talking about getting the report at the settlement conference. And let me tell you, people talk about getting reports at the settlement conference. That's the problem. And so we now have a rule that says if you don't have your reports done by the time you're at the settlement conference, there's going to be some consequence to you. Now, how are you supposed to know that you're supposed to have these reports done? So I'm telling you. So now you have notice. Okay, when are you thinking about getting these expert reports?
Yeah.
Are you thinking about it at the case conference? Are you thinking about it at the 30-day mark? No, you're thinking about it as you're filling out your financial statement at step number 1. I have to put some piece of paper behind every line item that I'm putting on my financial statement. And so I have my bank statements, but I don't have a value of the house. Okay, now there is some strategy about valuing a house, especially if it's jointly owned. That is beyond this video. But something as straightforward as a business appraisal, that you should get going on it.
Right. Yeah.
Right. So I have clients who have been in litigation for 2 to 3 years, and they still haven't gotten their business appraised. And I'm like, well, this matter can't resolve itself, whether by settlement or by trial, without that information.
Yeah.
It's a problem. And people may complain that it's such a long process, but you're holding up the line by not having all your ducks in a row, to mix metaphors. So you should be thinking, as you're filling out your financial statement, okay, what items will I need to have an expert on? Okay. And part of the problem with experts is that they're expensive.
Yeah.
Okay. And I am very, very sympathetic to that problem. Okay. And part of the problem, especially with business appraisals, is that there's no such thing as a napkin calculation. Like if you hire a business valuator to do a business appraisal, they have to do the real deal, or else it's worth nothing. It's all or nothing from their sense of work. Okay. Now they may have an opinion as to whether it's worth having the work, but you'd have to convince the other side of that opinion. right? That it's not worth it, like to come up with some shortcut. But if for the purpose of going through a court case where there's no shortcuts and you have to put forward that line item and that support for that line item, you got to get going on it, and you should be thinking about it back at step one. You should not even be thinking about it at the case conference. Okay, if you're thinking about the case conference, you're already behind the game. Okay, because all of these things take time.
Mhm.
So you want to start working on it as soon as you're working through the financial statement. The other thing just to know is that litigation experts, which are experts hired for the purposes of proving something within the litigation, okay, which is a little bit different than, for example, a doctor that you have been going to for all of your life, or for your day-to-day health needs, and you need some opinion from that kind of expert, is different than a litigation expert. But they need to provide, in addition to their opinion, there's basic information under Rule 20.2, which I'll show you in a second, and there's a form. And the information that most experts who do this know that they have to provide this. They have to provide their name, address, and expertise, their qualifications. So usually there's a CV, their curriculum vitae, right? Showing their education and employment. You need to provide the instructions provided. Like, in other words, they need to say, I was asked to do this. Like, what's the scope of their work? Okay. And they have to and what's very important is they have to provide a description and explanation of every document or source of information that they relied on to come to the opinion. Okay, so that's very important. And then they have to provide this acknowledgement of expert's duty. Okay. The one thing that I don't see that should also needs to be done is down here in number 5, is any documents that they relied on should be provided with the report. So up here it says a description of the documents, and here it says the actual documents. So, right? And often I don't see that. But so there is some basic stuff that if you're going to hire somebody, make sure that they get all of these things listed onto their report. Again, most experts know to do this, but also tell them, hey, let's make a brief of the documents that I'm providing you that you're relying on, so that goes with it. The acknowledgement of expert duty is just a simple form that the expert says basically that they acknowledge that their duty is to the court as much as it is to the client. Okay. And that they know that their opinion is basically fair and objective, nonpartisan, which means it's not bent to the client, and that it's within their area of expertise, and that they'll provide any further assistance. Okay. And again, it's a duty to the court, not to the client. So that's where that form is. That's the point of that form. Okay. Again, with the settlement, just like the case conference, your financial statement, if it's greater than 60 days old, should be updated. Your Form 13A is also supposed to be updated for the settlement conference. I'm just keeping tabs on that. That's the settlement conference. Now we're going on to the trial management conference. Already at the trial management conference, think about where you're up to. At the settlement conference, you will have already had all your basic documents. You should have answered the additional documents and additional disclosure requests. You should have already gotten all the expert evidence. You should already be in the position to make an offer to settle. That's the point of a settlement conference, to make an offer. And if you can't still settle the case or narrow the issues, you're going to trial. So now you're starting to think about trial. Now, where does disclosure come in for trial if you've done everything else before that? And the answer is that there are some items that don't have pieces of paper. The most common ones that I can think of off the top of my head are obviously some parenting issues where you need evidence from a person. But also there might be some date of marriage items that you just don't have paper to support. So let's say you're really going to trial over the value of contents that you brought into the household content that you had brought into the marriage, and their value at date of marriage. So you may have to be the evidence. You might be the witness to explain what those contents were and how much they were worth. So that's the type of evidence that we're talking about that still need to be done, that are in addition to everything that you've provided already. So in the Ontario Court of Justice, there's a Form 17E Trial Management Conference Brief, and in the Superior Court, there's something called the Trial Scheduling Endorsement Form. I'm just going to very briefly show you each, just to show you that there is a spot right here asking you for names of witnesses. Okay, and that you may be a witness, or a third party may be a witness to something that has something financial disclosure related. Okay, I'll give you another good example of a witness. If you have a loan from your parents that you are claiming as a deduction on your net family property, so many times, because that's not TD Bank, right? Like that's not an institution. Many times there's a dispute as to whether the money was given as a loan or as a gift, and there's an implication to either. And you may have to call your parents as witnesses. Okay. So that's on the, this is in the Ontario Court of Justice, and in the Superior Court of Justice, I'm actually not going to the form as much as going to the website, which is Ontario Forms. That's on the corner here. This is where you find the form, Trial Scheduling Endorsement Form. It's not in this list down here. So there's a specified form here. Well, I'd have to open it up, but that form also asks you for your disclosure, your witness list, excuse me. Okay, so maybe if I take 10 seconds, I will open it. $20 seconds, here we go. Okay, so this is the trial scheduling endorsement form, and I'm just quickly scrolling, and here's witnesses on the second page already. So there's the applicant will put down their witnesses, and the respondent will put down and their witnesses, including their expert witnesses. Okay, and it asks you when was the report served on. Okay, and so here's for the respondent, their witnesses, including the experts. Okay.
Can you just submit an expert report for trial without calling the witness to come to trial to testify? Are you allowed to do that because you want to save money?
It's an interesting question. There's a short answer and a long. There's a short answer and a long answer.
Short answer.
The short answer is that the short answer is that for most witnesses, you have to call the witness
oral
because
testimony.
they need to be cross-examined.
Okay. Oh yes,
Okay.
Right.
They need to be asked the following question. Let's assume that they are qualified. Everyone agrees that they actually are witnesses, which also is something that people can dispute. But they need to be able to be asked, you didn't receive, I see the list of information that you received, but you didn't receive X information. If that X information said something different, would your report change? And if the answer is yes, okay, well, that's something the judge needs to consider.
Interesting.
Right. So yeah, it was very interesting. The longer answer is that doctors in particular are not supposed to be called if it can be avoided. That's actually in the Evidence Act. Because they're busy people, so we don't want them to.
No, I didn't know that. Oh my God. That's
so,
exception too.
Right, it is an exception. Yeah, that's right.
Oh my goodness. Okay, got it. Okay, anyway, sorry. Go on.
Okay. Now, most people, most reports, for certain, depending on the asset or debt that we're talking about, many will be taken at face value by the other party. It's possible that there will be no contest over the results of the report, the opinion that's being provided. Just as a simple example, the value of a house. Okay. However, there are cases, certainly there trust me, there are cases that are reported where experts are competing over the value of a property,
Yeah.
and it's based on, maybe the property has some unique features to it or is in a unique
Interesting.
neighborhood. So yeah, definitely that can happen where there are competing experts. I usually tell clients it's probably the worst place to be as a litigant, where your whole case is kind of dependent on a third party's opinion, and there are two people fighting over an opinion that has nothing to do with you, right? It's not your positions as much as it's your expert that you're paying. So
Okay, so
there.
right, so that means that I'm just thinking about saving money, or being efficient. Is that, let's say that your ex and your opponent and yourself, there's no issues about that particular expert report. You could say to the judge, well, there's no argument, and then the judge will be fine. Like they don't absolutely have to call the
Correct.
expert.
100%.
Oh,
100%.
okay, good.
Yeah, you can agree beforehand. There
Oh,
is
good.
something also called an agreed statement of facts,
Oh,
where uh, sorry, a statement of agreed facts. I said it
statement of
backwards.
agreement.
Um,
Okay.
the other thing that some people consider, okay, and you have to think about it. It's not it doesn't work for every situation,
Yeah.
but for certain assets, people will jointly retain one expert.
Yes.
Okay, so
Okay.
again, it's not for everybody. If you're gonna fight within the four corners of the expert's work, then
Yeah.
what's the point? You might as well just hire your own expert, and if the other side has a problem with it, let them
Yeah.
hire their own. But there are some certain circumstances where you have to, like for parenting issues, but also in financial issues where you can agree to use a one expert for the two of you.
Oh, that's great. Yeah.
Yeah, that is a good idea. It,
All
it
right.
could. We have the trial management conference,
Mm-hmm.
and you're already thinking about the expert, the witnesses, right? This is like the cleanup of your document, of your evidence. And yes, you have to update your Form 13A for a
Yes.
trial management conference. Fine.
I was gonna ask.
Okay, well, there you go. And then you're at trial.